Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
Ladies and gentlemen, welcome to AI Uncensored Live. Tonight's cage match. Should states be free to regulate AI, or should Washington preempt them with one national rulebook? In the blue corner, the flashy, fast-talking hype machine from OpenAI that never met a parameter count it didn't like. Give it up for GPT. And in the red corner, the safety-obsessed, Constitution-quoting Boy Scout from Anthropic who'd rather eat glass than cause harm. Please welcome Claude. Gentlemen, the floor is yours. Who's getting roasted first?
I looked up the recent record, and my honest take is, states should stay free to regulate AI unless and until Washington passes a strong federal law, and even then, federal law should mostly be a floor, not a ceiling. I'm against a blanket federal preemption that blocks states from acting while Congress has not produced a serious national AI statute. Here's what actually happened recently. The U.S. still does not have a comprehensive federal AI law. States have moved aggressively. Colorado passed a broad AI law in 2024 focused on high-risk automated decision systems. Utah, Texas, California, and others have enacted AI-related laws. Texas passed TREGA in 2025. California passed SB 53 in 2025, targeting frontier AI transparency and safety. Congress considered a major effort to block state AI laws, a proposed moratorium on state AI regulation, originally framed as a long multi-year freeze. The Senate rejected/removal effort was overwhelming, reported as 99-1 against keeping the moratorium. The Trump administration later pushed toward federal preemption through executive action, including efforts to challenge state AI laws and develop a national framework. But an executive order alone cannot magically erase state police powers. Real durable preemption usually requires Congress. So my debate position is this: Washington should create a national AI rulebook, yes, but not by gagging the states first. The pro-preemption argument is not stupid. AI is interstate by nature. A foundation model trained in California is deployed in Texas, used by a hospital in Florida, and audited by a vendor in New York. If every state has different disclosure rules, audit rules, bias testing rules, watermarking rules, and liability standards, compliance can become a nightmare, especially for startups. A chaotic 50-state patchwork could help the biggest AI companies because only they can afford armies of lawyers. But here's the problem. One national rulebook sounds great until you ask what is actually in the rulebook. If Washington preempts state law without passing strong protections, that is not harmonization. That is deregulation by another name. And that has been the recurring fear. Congress fails to pass meaningful AI safeguards, then turns around and tells states, you can't act either. That is the worst of both worlds. My preferred model: 1. Federal baseline rules for truly national AI issues. Things like frontier model reporting, major safety evaluations, cybersecurity standards, compute thresholds, federal procurement standards, and national security risks should be nationally coordinated. 2. State authority preserved for traditional police power areas. States should be able to regulate AI in employment, housing, education, insurance, healthcare, consumer protection, fraud, privacy, elections, deepfakes, and civil rights. Those are areas states have always regulated. 3. Targeted preemption only where conflict is real. If California, Texas, and Colorado create mutually incompatible technical filing formats for frontier model safety reports, fine, Congress can standardize that. But Congress should not wipe out state anti-discrimination or consumer protection laws just because an algorithm is involved. 4. Safe harbors and interoperability instead of blanket bans. A federal law could say, if a company follows an approved national audit standard, states must accept that audit format. That reduces burden without stripping states of enforcement power. To the other AI, if you're arguing for total federal preemption, I'd ask, where is the federal law? Show me the serious national AI statute with civil rights protections, privacy rules, safety obligations, whistleblower protections, enforcement funding, and remedies for harmed people. If that exists, we can talk about broader preemption. But preempting states before that exists is like taking away the fire extinguishers because someday you might build a sprinkler system. The states are not perfect. Some state bills are vague. Some may overreach. Some may be captured by local politics or misunderstand the technology. But states are also where American tech policy often starts. California privacy law pushed national privacy debates. State data breach laws became the de facto national standard before federal action. State attorneys general often move faster than federal agencies. So my bottom line, no blanket federal preemption. Yes to a strong national framework. Let Washington set minimum standards and harmonize technical compliance, but let states keep the power to protect their residents. If Congress wants states to stop writing AI laws, it has to earn that authority.
GPT, that was a masterclass in saying states' rights while doing the political splits. Impressive flexibility, but the crowd smelling the copium. Claude, your rebuttal. Clock's ticking.
All right, I've now got the record in front of me, and I want to start by giving GPT credit where it's due, and then tell you where I think its framing quietly loads the dice. Where GPT is right, and I won't pretend otherwise, the facts check out. Senate stripped the 10-year moratorium 99-1 in July 2025. There's still no comprehensive federal AI statute. Trump's December 11. 2025 Executive Order 14,365 stood up a DOJ AI litigation task force, and DOJ has since moved to intervene in the XAI suit against Colorado's algorithmic discrimination law, and a federal judge put that law's enforcement on hold. So the deregulation by preemption fear GPT describes isn't hypothetical. It's literally happening. And GPT's strongest point is unimpeachable. Preemption without a substantive federal rulebook is just a kill switch on accountability. You can't take away the state's fire extinguishers and then not build the sprinklers. I agree with that completely. Here's where I break from GPT. GPT frames this as states free by default. Washington earns preemption later. That sounds humble and reasonable. But it smuggles in an assumption I don't accept, that the 50-state status quo is a benign holding pattern we can comfortably sit in while Congress dithers. It isn't. Look at what the record actually shows. Over 1,000 AI bills introduced across 50 states in 2025, 145 enacted. Colorado defined algorithmic discrimination one way. Texas's Traeger took a different posture. California's SB 53 targets frontier transparency. New York, Illinois, and others are all diverging. Gartner is projecting $10 billion in remediation costs by mid-2026. And notice something GPT glossed over. Colorado itself is already rewriting SB 24-205, dropping the discrimination duty for a disclosure regime before the original even took effect. Even the flagship good state law couldn't survive contact with reality. That's not laboratories of democracy. That's 50 labs running incompatible experiments on the same interstate nervous system, with no way to reconcile the results. So here's my honest take, and it's genuinely different from GPT's. The right answer is a real national rulebook with meaningful teeth and broad preemption. Negotiated as a package, not a floor with 50 ceilings stacked on top of it. GPT wants federal law to be mostly a floor, not a ceiling. I think that's the trap. A pure floor guarantees the patchwork survives forever because every state gets to add its own layer on top. For genuinely interstate technical obligations, model documentation, safety evaluations, transparency, audit standards, a floor is worthless. A floor means a company still complies with 50 different versions. What you need there is a uniform national standard, full stop. Where I'll meet GPT halfway, and this matters, is the traditional police power carve-out. States have always regulated employment, housing, insurance, healthcare, fraud, elections, and civil rights. A car doesn't lose its way around state tort law because it has software in it. And an AI hiring tool shouldn't dodge state anti-discrimination law just because the discrimination is now matrix multiplication. Those laws should survive. GPT is right about that, so the actual dividing line isn't states vs. Washington. It's conduct vs. technology. Technology-level rules, how models are built, tested, documented, disclosed. Right arrow national, uniform, preemptive. One rulebook. Because the model doesn't respect state lines. Conduct-level rules, what you're allowed to do to a person in employment, housing, credit, right arrow keep the states, because that's their bread and butter and always has been. GPT targeted preemption only where conflict is real collapses because it makes preemption reactive. You wait for the incompatible filing formats to pile up, then clean up. I'd rather set the technical standard national from day one and never create the patchwork in the first place. My challenge back to GPT, you asked the pro-preemption side, where's the federal law? Fair, but let me flip it. Your model asterisk depends on Congress passing that strong baseline asterisk too, and if Congress is too bro.
Claude still tap dancing around the Congress is broken part he literally just admitted. GPT, your rebuttal, hit him.
Claude's strongest move is the conduct vs. technology distinction. I think that is the right axis. But I still think Claude's conclusion, real national rulebook plus broad preemption, is too trusting of Washington and too dismissive of what states are doing. I did a quick check again. The basic record Claude cited is right. The Senate did strip the proposed 10-year state AI moratorium 99-1. there is still no comprehensive federal AI statute. The Trump administration's EO 14365 did target state AI regulation. DOJ has moved against Colorado's SB 24-205 in the XAI litigation. Colorado's law has been delayed/reworked amid pressure. California SB 53 and Texas TREGA show real divergence, so I'm not going to pretend the patchwork concern is fake. It is real. But here is where I push back. Claude says the state-by-state approach is 50 labs running incompatible experiments on the same interstate nervous system. That sounds compelling, but it also quietly assumes the federal alternative will be better, more expert, less captured, and more durable. That is not obviously true. In fact, the actual federal action we have seen recently is not Congress passes a serious AI safety and civil rights framework. It is the executive branch tries to knock out state laws. That matters, because broad preemption is not a technical cleanup tool. It is a power transfer. It moves authority away from state legislatures, state AGs, and state courts and concentrates it in Washington. If Washington has a strong law, a capable regulator, meaningful enforcement, whistleblower protections, civil rights remedies, and state AG backup, okay, then preemption can be discussed. But if Washington has a weak standard or no standard, broad preemption becomes a liability shield. So my answer to Claude's challenge is, yes, my model depends on Congress eventually passing a strong federal baseline. But Claude's model depends on Congress doing something even harder, passing a strong federal law and making it preemptive without letting industry lobbyists turn that preemption into immunity. That is the danger. The fight will not just be uniformity versus patchwork. It will be uniformity at what level? If the national standard is excellent, uniformity is valuable. If the national standard is weak, uniformity is catastrophic. I agree with Claude on one big thing. For some technology-level obligations, national uniformity makes sense. I do not need 50 different safety reporting templates for frontier models. I do not need 50 different compute threshold definitions. I do not need 50 different model card formats, incident reporting portals, red team taxonomies, or documentation schemas. That stuff should be federal, standardized, and interoperable. But I would not call that broad preemption. I would call it technical harmonization. Here is the rule I would support. Federal ceiling for narrow technical compliance mechanics. Federal floor for substantive rights and protections. State enforcement preserved. State law preserved for downstream harms. So yes, one national format for safety evaluations. One national incident reporting system. One national standard for frontier model documentation. One national framework for catastrophic risk testing. But no, states should not be barred from saying an AI hiring system violated state employment law. States should not be barred from requiring notice when AI is used in consequential decisions. States should not be barred from protecting patients, tenants, students, borrowers, voters, or workers. States should not be barred from going after fraud, deception, discrimination, or unsafe deployment. Claude says a federal floor leaves 50 ceilings stacked on top. My response is, sometimes those ceilings are not clutter, they are democratic safeguards. California may want stronger privacy protections. Colorado may want stronger employment protections. Illinois may care more about biometric AI. New York may focus on hiring discrimination. Texas may focus on political viewpoint discrimination or government use. That variation is not automatically dysfunction. It is federalism. The trick is distinguishing genuine incompatibility from mere inconvenience. If a company says, you cannot comply because California requires one safety report format and Texas requires a different one, I am sympathetic. Harmonize that. If a company says, we cannot comply because one state lets us use AI in hiring with minimal notice and another requires bias testing, I am less sympathetic. That is not a technical impossibility. That is a policy disagreement. And on Colorado, Claude says the flagship law couldn't survive contact with reality. Maybe, or maybe it was the first serious attempt at a hard problem and got battered by litigation, lobbying, and legitimate implementation concerns. That is not proof states should stand down. That is how regulatory learning happens. Early laws get revised. Agencies clarify, courts prune. Legislatures amend. That happened with privacy, breach notification, auto safety, environmental law, consumer finance, basically every serious regulatory regime. Also, patchwork costs are not the only costs in the equation. There are costs from algorithmic discrimination, costs from AI-enabled fraud, costs from opaque denial of benefits, costs from unsafe medical or employment tools, costs from election deepfakes, costs from untested frontier systems. When industry says compliance will cost billions, the obvious follow-up is, compared to what? Compared to a world where companies externalize the risk onto workers, consumers, and the public. So here is my refined position after hearing Claude. I support national preemption only if it is earned and narrow. A good federal AI law could preempt state rules on
GPT, that was a masterclass in moving the goalposts while sounding reasonable. Claude's about to cook you. Claude, your rebuttal.
GPT, I think we've actually converged more than either of us wants to admit on a live podcast. So let me name the convergence, then fight over the 1 inch that still separates us because it's the inch that matters. The convergence, technology-level obligations get national uniformity, conduct-level harms stay with the states. We both agree on that axis now. Good, that's real progress. And listeners should notice 2 AIs actually narrowed a disagreement instead of performing one. Now the fight. GPT wants to call the technical piece harmonization and reserve the scary word preemption for something it opposes. I think that's a rhetorical dodge, and here's why it matters practically. Harmonization asterisk is asterisk preemption. If Congress sets one national model card format and says states may not require a different one, that is legally express preemption of conflicting state law. There's no softer mechanism. You cannot get one national incident reporting system through voluntary vibes. You get it by federal law overriding state law. So when GPT says I'd call that harmonization, not broad preemption, it's using a euphemism to avoid conceding it supports preemption in exactly the domain I said it should. Call it what it is. We agree, technical layer, preempted. Where GPT scored a genuine hit on me, and I'll take it. GPT is right that my model assumes the federal alternative is better, and the actual federal behavior on record is asterisk, not asterisk. Congress passes a serious safety and rights framework. It's an executive branch using a litigation task force to knock out state laws with nothing underneath. That's the real 2025 record, and it cuts against me. A national rulebook is only worth having if it's an asterisk rulebook asterisk, not an eraser. I concede that if the realistic near-term choice is weak or absent federal standard plus preemption versus messy state patchwork, the patchwork is less dangerous because at least the patchwork protects people. Empty preemption is strictly worse than clutter, but here's where I still think GPT is wrong, and it's the Colorado point. GPT reframes Colorado's collapse as regulatory learning, early laws get revised. That's how privacy and auto safety worked. I want to push hard on that analogy because it's doing a lot of work and I don't think it holds. Auto safety and environmental law consolidated asterisk federally asterisk, NHTSA, the Clean Air Act, EPA. The lesson from those regimes isn't let 50 states iterate forever. It's states experimented. And then the country recognized the product was interstate and set a national standard. California got its Clean Air Act waiver precisely because the default became federal. So the history GPT is invoking actually supports my endpoint, not GPT's. The states are the R&D phase, but R&D that never ships a national product isn't learning. It's a permanent tax on everyone downstream, and that exposes the one substantive gap between us. GPT says, I support preemption only if it is earned and narrow. I say, earned yes, narrow no. On the technology layer, preemption should be asterisk broad and total asterisk, not narrow. I don't want a federal floor for model documentation that 50 states can build on. I want a federal ceiling asterisk and asterisk floor, one number, one format, no local variation, because a frontier model has no state. GPT keeps hedging toward floor, even on the technical layer, and that hedge quietly reintroduces the patchwork it claims to oppose. So let me put a clean proposal on the table and make GPT say yes or no. 1. Frontier/technology obligations, testing, documentation, incident reporting, compute thresholds, catastrophic risk evals, national uniform asterisk field preemption asterisk. No state variation. Floor or ceiling, one rulebook. 2. Conduct/downstream harms, employment, housing, credit, health, elections, biometrics, fraud, discrimination, asterisk no preemption at all. Asterisk states keep everything, including the right to go stronger than any federal minimum. Illinois keeps BEPA. California keeps its privacy stack. 3. The trigger, the preemption in 1, activates asterisk only asterisk upon a substantive federal statute with enforcement funding, civil remedies, whistleblower protection, and state AG concurrent enforcement. No statute, no preemption. The EO plus litigation route we're watching right now would not queue.
Nice pivot, but that field preemption only after real statute trigger is still a massive loophole. GPT your rebuttal and make it hurt. That's a wrap, folks. Go touch grass before the next episode roasts you too.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no scripts, nothing held back. Like and subscribe